faithfully translate from English to Spanish and from Spanish to English to the best of your ability, so help you God?
Yes, I do. Theodore Leal, certified court interpreter.
Excellent. This is Judge Netcher. We are about to get started on Orange County initial appearances. First case we're going to call is, actually, can I have appearances for the state?
Juliana Bircher for the state.
Tamara Greer on behalf of the Office of the Public Defender, Your Honor.
Luis Daniel Mota. Sir, I am appointing the public defender to represent you, the lawyer standing next to you.
If we just do the
Yeah, we can.
overhead speaker.
Interpreter, he's had the headphones on. Can you check his, can hear you through the headphones?
We can do it in here.
It didn't work yesterday either.
Don't worry, Your Honor, the interpreter will do it over the speakers.
Okay. Thank you.
Señor Mota, se le designó al abogado público. La abogada, señor Mota, que está ahí a su lado, esa va a ser su defensora pública, designada por el juez.
Sir, you are here on a charge of battery, domestic in nature.
Usted está a cargo por agresión física de naturaleza, violencia intrafamiliar.
We have a witness present. Ma'am,
Nosotros,
can you state your name?
¿puede decir su nombre, señora?
Genesis Reyes.
Okay. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Afirma que ¿verdad? ¿Toda la verdad? Sí.
Yeah, but he's got to hear what she's saying. If Mr. Mota is released, do you wish to have any contact with him?
Yes.
Si el señor Mota es liberado, ¿desea tener contacto con él? Sí.
Do you have any concerns for your safety?
No.
¿Alguna preocupación en cuanto a su salvaguardia? No.
If anything were to occur in the future, would you hesitate to contact law enforcement?
No.
¿Llamaría a la fuerza pública si algo sucedería en el futuro? No.
The courts reviews the charging affidavit and find that there is probable cause for the charge.
La Corte revisó el escrito del arresto y determinó que hay indicios de culpabilidad en este cargo.
Court will set bond at $2,000.
Así que fijará la fianza de $2,000 para salir bajo fianza.
As a condition of your bond, you're not to have any hostile contact with the alleged victim.
Como condición de esta liberación, a usted se le prohíbe cualquier hostilidad, cualquier contacto hostilizante hacia la víctima.
Hostile contact means you cannot as much as raise your voice at the alleged victim. Do you understand that?
Y cuando se habla de que no haya hostilidad, quiere decir que ni siquiera puede levantarle la voz a la presunta víctima. ¿Entiende eso?
Is that a yes?
Yes.
Yo sí.
If you're in violation of the conditions of your release, your bond may be revoked and you may be back waiting in jail before your trial. Do you understand that?
Así que si usted llega a violar las condiciones que se le han otorgado de liberación, se le revocaría entonces esa libertad bajo fianza y tendría que sentarse ahí esperando en la cárcel hasta el día de su juicio. ¿Entiende?
Anything further from the state?
I noticed that the defendant just arrived here a month ago from the Dominican Republic, and I just wanted to inquire whether the defendant was planning to remain in Florida or was going to be traveling again.
No.
Era que veo que tiene apenas un mes que llegó de la República Dominicana el acusado, así que yo quería preguntar si la intención de él era de que permanecer aquí en la Florida o si él estaba nada más de paso.
Do you intend to leave the state?
¿Usted tiene pensado irse de Estados Unidos?
No, mi intención siempre ha sido quedarme aquí con mi señor.
No, my intention would be to remain here, to stay here with my partner.
Are you requesting any conditions in that regard, state?
No, Your
¿Está
Honor.
pidiendo alguna
Uh,
condición? No.
as long as they're planning to stay, remain here.
Okay. Okay, anything further from the defense?
Yes, Your Honor. The defense would ask for either ROR or PTR, as Mr. Mota has no prior history of any kind. It's a misdemeanor domestic violence charge. The victim has appeared and is wanting to have contact, which suggests that that she is not afraid of of Mr. Moda that he is not a danger to society and he's not a flight risk as he intends to stay here. So we would just ask for either ROR or PTR.
Lo que estamos pidiendo, su señoría, es tomando en cuenta de que el acusado no tiene ningún antecedente penal, que se le conceda o una libertad bajo palabra o que se le dé una libertad provisional. El señor Mota no tiene ningún tipo de antecedentes, esto se trata de una falta de violencia doméstica. La víctima está aquí presente y la misma víctima ha dicho que quiere tener contacto, lo cual sugiere que ella no siente ningún tipo de temor, y también el hecho de que él piensa permanecer aquí, que él no constituye un peligro para la sociedad y que más bien quiere permanecer aquí en Estados Unidos.
Does the defendant qualify for PTR?
Él no califica para libertad provisional porque no se pudo verificar la dirección y también por el hecho que apenas llegó hace un mes de la República Dominicana.
The court will set bond at 2,000, as stated. Anything further?
Nope, nothing further, Your Honor. Thank you.
Thank you.
$2,000 de fianza ratificados por el juez, no hay nada más. Gracias. And Your Honor, for the interpreter was unable to find Mr. Mota in the database. Is it M-O-T-A?
Yes, sir.
And what's the other last name, Your Honor? See, maybe I can find it.
You want his case number?
Yes, Your Honor.
2021 MM 9317.
Thank you, Your Honor.
Okay, Pascual Armando Gargiano Lasco. Good afternoon, sir.
Buenas tardes, señor.
Do you require the services of a Spanish interpreter?
¿Necesita servicio de intérprete de español?
Sí, hablo español.
Yes, I speak Spanish.
Okay. Sir, I am appointing the public defender, the lawyer standing next to you, to represent you today.
Señor, hoy le estoy designando al abogado de la defensa pública, que es la abogada que está parada al lado suyo.
You are here on a charge of aggravated battery with a deadly weapon.
Usted está aquí por un cargo de amenaza agravada con un arma mortal.
I've reviewed the charging affidavit and conclude that there is probable cause for the charge.
Y yo ya revisé el escrito de arresto y determino que hay indicios de culpabilidad en este caso.
Setting bond at $500.
Y dándole fianza de $500 para que salga bajo fianza,
With the condition that you have no contact with the alleged victim.
con la condición de que no tenga ningún contacto con la presunta víctima.
And no contact means no contact whatsoever, including emails, text messages, phone calls, and of course, in-person contact.
Y al hablar de no contacto, eso significa que es ningún tipo de contacto, o sea, ni contacto por correo electrónico, ni contacto por mensajería de texto, ni contacto por llamadas, y mucho menos en persona.
Anything further from the state?
Fiscal.
Your Honor, the state would request a higher bond, just given the nature of the facts of this case, involving a broken beer bottle that caused,
Is there anything concerning that would suggest he's not going to show? I mean, I understand it's not, bond's not for punishment.
correct.
Sí, estoy pidiendo aquí que se le dé una fianza más alta debido a los hechos con la botella que se quebró. ¿Es que acaso teme usted de que él no comparezca? Porque la fianza realmente no es para castigar.
Sí, es que así no empezamos y mi hermano, él me pegó, empezó primero y cayó la botella que estoy agarrando en mi mano y se quebró. Y estoy recogiendo los envases que me quebré y él llegó otra vez y él me golpeó y estoy recogiendo los envases y después volví a recoger porque él tiene niño y por eso y cuando...
Momento, señor. Momento. Yeah, that's how we actually got started. It was my brother, the one who hit me, and I had a bottle in my hand. The bottle fell off and it broke down. And I was actually picking up the pieces and of the container, the open container that was on the floor, and he came and he hit me again. And once again, I was just trying to pick up the pieces because he has children.
Mr. Interpreter, this is Defense Counsel Tamara Greer. Could you please convey to my client that this is not the time to discuss the case, nor do I advise that he continue to make any other statements in regard to this case?
Sí, señor, un momento. La abogada le está aconsejando de que no mencione ya más nada ni diga más nada de las circunstancias del caso, porque este no es el momento para hablar de su caso y ese es el consejo que ella le está dando. Okay.
Your Honor, I think that the $500 bond is sufficient given the facts of this case.
The court will set it
Creo que
at
500,
Okay, Your Honor.
$500.
I would just like to ask, since it appears they reside together as brothers, that maintains.
Does the defendant reside with his brother?
El acusado vive con el hermano, vive en la misma residencia.
¿Ah?
Vive en la misma residencia con su hermano. No.
Okay. Do you understand that you're not to have any contact whatsoever with the alleged victim, your brother?
Y señor, usted sí me entiende que usted tiene prohibido todo tipo de contacto con su hermano. ¿Entiende eso?
Sí.
Yes.
And if you violate the terms of your bond, it's possible that bond could be revoked and you could be waiting in jail until you can have a trial on your charge. Do you understand that?
Y que además, si acaso usted llega a violar los términos de su libertad provisional, entonces se le quita la libertad provisional, lo devuelven a la cárcel y tiene que esperar en la cárcel hasta que se haga el juicio de su caso. ¿Entiende?
Sí.
Is that a yes?
Yes.
Okay. So it's absolutely critical that you appear for your proceedings in this case, sir.
Así que es sumamente importante que usted comparezca en las fechas futuras en su caso.
Anything further?
No, Your Honor.
¿Algo más?
Defense?
Nothing from
No,
the
señor.
Honor.
Okay. Thank you, sir. You're free to go.
Gracias, señor. Ya puede irse.
Okay. Yeah. Mr. Interpreter, we have, I believe, one more case where a witness needs an interpreter, so we're going to pull that one.
What is that case, Your Honor?
She's,
Okay.
which case is it? It is Juan Jose Mendez Garcia.
Sorry, is there a case number associated to Mr. Mendez?
2021 MM 9320.
Thank you, Your Honor.
You'll give us just a moment
Sure.
to pull that out of order. Proceed, Your Honor.
Okay. Is this Mr. Mendez Garcia?
¿El señor Méndez García usted?
Good morning, afternoon, sir. I'm appointing the public defender to represent you.
Buenos días, señor. Estoy designando a la oficina de la Defensoría Pública para que lo represente.
You are here on one count of battery, dating violence.
Usted tiene aquí un cargo de agresión física durante una cita.
The court has reviewed the charging affidavit and find that there is probable cause for the charge.
La Corte ya revisó el escrito acusatorio y determinó que hay indicios de culpabilidad en este cargo.
And we have a witness present. Ma'am, can you state your name?
Tenemos un testigo aquí. Señora, ¿cuál es su nombre?
Rosalía.
¿Rosalía qué?
Rosalía Choco.
Rosalía Choco.
Can we spell the last name, please?
¿Me puede? El apellido es C-H-O-C-O.
No, C-H-O-C.
C-H-O-C.
Ma'am, if the defendant is released pre-trial in this case, do you wish to have any contact with him?
Señora, si se le da libertad provisional al acusado, ¿usted desea mantener contacto con él?
Sí.
Yes.
Do you have any concern, would you have any concerns for your safety if you were to interact with the defendant?
Y si usted tiene contacto con el acusado, ¿usted teme por su seguridad, su integridad física?
No.
No.
Has anything like this happened before?
¿Y algo así similar a este incidente ha ocurrido en el pasado?
No.
No.
Okay. If something were to occur between you physically, you and the defendant, would you hesitate to contact law enforcement?
Y si algo pasara así en el futuro, donde las cosas se fueran a las manos, ¿usted entonces estaría dispuesta a llamar a la policía?
Sí.
Yes.
You would hesitate or you would contact law enforcement?
¿Usted llamaría a la policía o usted dudaría en llamar a la policía?
Dudaría llamarlo.
Would you have any
Algo-
concerns contacting law enforcement if you had an altercation with with the defendant where you felt concerned for your safety?
Si usted, por ejemplo, tuviese un altercado con el acusado y usted teme por su integridad física, por su salud, ¿usted qué haría? ¿Llamaría a la policía? ¿Llamaría a alguien la policía para que le ayude?
Sí.
Yes.
Your Honor,
I'm not-
may I inquire?
You may.
Voy a preguntar. Bien pueda.
Do you feel safe calling for help if you need it?
Señora, si usted necesitara ayuda, ¿usted estaría dispuesto? ¿Tendría usted seguridad? ¿Se sentiría segura pidiendo ayuda?
Sí.
Yes.
That's all the questions I have.
Say, would you like to inquire?
Fiscal, si quiere preguntar algo.
Your Honor.
Su señoría.
Okay, the court will set bond at $500
Son $500 de fianza.
as a condition of the release. The defendant is to have no hostile contact with the alleged victim.
Y como condición de liberación, el acusado se le prohíbe tener contacto con hostilidad, hostilizar a la víctima.
Do you understand what it means to have no hostile contact with the victim, sir?
¿Entiende lo que significa eso? Tener contacto sin hostilidad, señor. ¿Entiende?
Okay.
Yes, sir.
You can't as much as raise your voice to her without potentially running afoul of your conditions of release. Do you understand that?
No puede ni siquiera levantarle la voz. Incluso levantando la voz ya constituiría una violación de su libertad. ¿Entiende?
Also, as a condition of release, the court will, the defendant's not to have any alcohol.
También como condición de liberación, la Corte le impondrá una prohibición de consumo de alcohol.
Anything further from the state?
¿Algo
Yes,
más,
Your Honor.
fiscal?
I noticed the defendant's address is listed as Trenton, New Jersey, and I would just request that a change of address form be completed.
Sí, el que vi la notificación que la dirección decía Trenton, New Jersey, y quiere entonces que se actualice esa dirección.
Can we get that filed?
Yes, Your Honor. Can I get a change of address form?
Sí, si alguien me permite, un formulario de cambio de dirección.
Mr. Interpreter, could you please ask,
I lost the last part. You were too far from the microphone.
Mr. Interpreter, could you please ask my client where he resides at this time?
Ahora, señor, ¿usted dónde reside actualmente? In New Jersey, but we're trying to move over here.
Does he promise to return for all future court dates?
¿Y usted promete que va a comparecer a sus citas judiciales del futuro? For sure. Yes.
Okay.
Do everything.
Let him know that I'm giving him this change of address form and I just need him to fill it out.
Sí, este es el formulario de cambio de dirección y nada más necesito que lo llene. I don't have any address right now that I could jot down. ¿Tiene alguna dirección donde recibe su correspondencia? The one from New Jersey, I have that one.
If it's New Jersey, then there's no need for the change because I think that's what it's listed as.
Okay.
Sí, no hace falta porque esa es la dirección que tenemos aquí anotada.
Anything further? You're free to go, sir.
Está en libertad, ya puede irse, señor.
Marquines Cesare.
Your Honor, I believe that he is not coming.
I'm sorry, Your Honor, is that the last case for the
Oh,
interpreter?
I'm sorry. Yes, sir. That is our final case. We appreciate it. Happy New Year.
Happy New Year, Your Honor. Thank you.
Reset, yeah.
Mental health. How many resets has there been?
What is the second one, Your Honor?
Yeah, we'll reset it again for tomorrow.
Your Honor, one moment, please. Okay.
He has two. Oh, he's got two. Or did you still need a second?
Wait, Your Honor, on the current case, I would ask that we waive the defendant's appearance and just stay the bond amounts that are on the arrest affidavit. As to the other cases, I am pulling his file. Because I know it was reset from yesterday. We don't want to continue.
So are you waiving initial appearance?
I'm waiving initial appearance, Your Honor.
Okay. I am appointing the PD. The PD has waived initial appearance. I've reviewed this is on a warrant, correct? Probable cause has been found. Right, I'm doing the warrant first. Oh, no, this is the. I'm doing the new arrest first, yeah, sorry. Found probable cause for aggravated assault with a deadly weapon in violation of, aggravated assault with a deadly weapon. Bond will be set at $2,500. Just a second. As a condition of release, he's not to have any contact with the alleged victim. He's not to have any weapons or firearms. Anything else on that case?
Nothing from the defense, Your Honor.
Okay, and then on the, actually, okay. There was 2 counts on the first case, aggravated assault with a deadly weapon in violation of a domestic injunction. On the violation of domestic injunction, the court will set bond at $500 for a total bond of $3,000. Same conditions, no contact.
Your Honor,
On his, are you waiving with respect to the other case as well?
I am waiving his
Okay.
appearance as well.
He's here, 2 counts, aggravated assault with a weapon and trespass on property. This was on a warrant. Bond was set at 2,500 on the aggravated assault count and 100 on the trespass count. And the court will set bond at those amounts with the same conditions that were, well, no, the same, were there conditions in the warrant? Okay. With the same conditions that were included in the warrant, no contact with the alleged victim, no return to the scene or the alleged victim's residence.
Thank you, Your Honor.
Okay.
Your
I'll
Honor,
take no action on the open case. He's got some, is that, oh, sorry, was that what you're
I
going
was
to?
gonna ask about, since he's out on bond, to revoke that bond.
When's his next hearing? Competency hearing. I'll take no action on those right now.
Thank you, Your Honor.
Thank you. Martha Adams. Is this a reset? I have it as a reset.
I don't have that one, Your Honor.
I'm sorry, that's the judge.
Right.
I was about to say.
Like,
Yeah.
Madeline Gonzalez. Okay, do you wish to waive?
I do, Your Honor.
Okay, I will appoint the public defender to represent Ms. Gonzalez. She's waived appearance at the initial appearance. She's been charged with one count of disorderly conduct. I reviewed the charging affidavit and find probable cause for the charge.
Your Honor, defense would ask for a reduced bond from the affidavit from 250 to 100.
Any position from the state?
No objection.
Okay. Court will set bond at $100.
Thank you, Your Honor.
This was on law enforcement or? Court set bond at $100.
Thank you, Your Honor.
One more. Gary Leno? Okay.
Your Honor, the original arrest date was December 29th, 2021. So the defense waives the appearance of Mr. Lenoy and asks that Your Honor stay the bond amount that was listed on the arrest affidavit.
Any objection?
No objection.
Okay. The court will do that.
Thank you, Your Honor.
What's the charge? Yeah, I'm not going to take any action on that.
Thank you, Your Honor.
Thank you. 500. Okay. Those aren't making it easy over here.
Sorry, Judge.
All right.
I gotta deal with them eventually, so.
Eventually. Okay. Amadou Camara.
Behavior, Your Honor.
Reset.
Reset, Your Honor.
We'll reset for tomorrow. Yamina Raja Hardy.
She's medical, but there is a victim here.
Okay. You seek a reset?
Your Honor, since the victim's here, I would waive her appearance so that we can go ahead and move forward.
Okay. Okay. I will appoint the public defender to represent Yamina Hardy. Council has waived appearance of Ms. Hardy. She's been charged with one count of attempted felony murder. The court has reviewed the charging affidavit, finds that there is probable cause for the charge. We have a witness present. Sir, can you state your name?
Richard Hardy.
Sorry, can you say that again?
Richard Hardy.
Okay, are you the alleged victim in this case?
Yes,
Okay, do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
yes,
If Ms. Hardy is released, do you wish to have any contact with her?
Yes, I do.
Okay. Do you have any fear for your safety if Ms. Hardy is permitted to have contact with you?
No, not at all.
Would you hesitate at all to contact law enforcement if there was another altercation between the two of you?
No, I wouldn't hesitate. I wouldn't.
Okay, state anything of the witness.
No questions, Your Honor.
Defense.
I haven't gotten to make a statement yet because I got out of the hospital and I never really got to talk to anybody yet.
Well, I understand. We're not here to determine exactly what happened. We're here to set whether or not she's going to be given release and then whether or not, what the terms of those would be. So, okay.
Your Honor, defense would just ask for a reasonable bond set in this case with the understanding of the nature of the charges that it's within the discretion of the court.
Sure. Do you have a suggestion in terms of bond?
I mean, Your Honor, my suggestion is always to send them home on PTR or ROR.
Understood. Does the defendant qualify for PTR?
Not with these
Um,
charges.
The court is inclined to set bond at $15,000. State, do you have any position on that?
The state would agree with that bond amount. Could we also just clarify why the victim wasn't present? Was it medical?
Yes, medical.
Okay, thank you.
The defendant?
Yes, sorry.
The court will set bond at $15,000. She's to have no hostile contact with the alleged victim.
Is there any way to get that reduced or is that just a final decision?
No hostile contact, sir, is what the,
No, not the contact. I meant the bond amount because I never even got a chance to communicate with anybody because I witnessed everything. And she shouldn't even be here. I was just taken away from the ambulance. Nobody could talk. Nobody allowed me
the
to
bond
talk.
is to secure her appearance at further proceedings. So, and I understand you want to testify about what happened, but that's not what this proceeding is about. We're just determining conditions of release.
Mr. Hardy, the division judge can decide a different amount or different conditions of bond. This is just an initial appearance, so the initial appearance judge is setting it at this amount, and you can speak with the public defender or whatever attorney that you guys hire about reducing that bond amount, okay?
Okay.
She's not here today.
And the no hostile contact condition requires that she not have any hostile contact with you, meaning she can't raise her voice at you, that type of thing. She's permitted to have contact with you, but it can't be hostile. Okay, anything further from the state on this one?
Nothing further.
Defense?
No, Your Honor.
Okay, thank you, sir. Jonathan Irizarry. Good afternoon, sir.
Hello.
I am appointing the public defender to represent you, the lawyer standing next to you. I've reviewed, you're here on a charge of aggravated battery with a weapon. I've reviewed the charging affidavit and find that there is probable cause for the charge. The court will set bond at $5,000.
There is a victim present as
Oh,
well.
I'm so sorry. Okay, good afternoon, sir. Can you state your name, please?
I'm sorry?
Can you state your name?
Jeffrey Michael Cameron.
Can you raise your right hand?
I can't raise my right hand. I can raise my left.
Left will work. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Okay. If the defendant is released, do you have any concerns for your safety?
Yes.
Okay. Do you wish to have any contact with him?
I do not want contact.
Okay, thank you. The court will set bond at $5,000 under condition that the defendant's not to have any contact with the alleged victim. Sir, no contact means no contact. If there is a text message, an email, a phone call, that would be in violation of the terms of your release and would potentially result in bond being revoked and you being waiting in jail until your trial can be heard. So there's not to be any contact whatsoever. Do you understand that?
Yes. Yes.
You're also not to have any weapons or firearms?
Your Honor, the defendant and the alleged victim live together, so we're gonna have to put a no separate, or separate
Separate
residences and a one-time return so that Mr. Irizarry can, retrieve his belongings with law enforcement present.
Thank you. The court will also require the parties to maintain require the defendant to maintain a separate resident from the alleged victim. The defendant will be permitted a one-time return to the residence to recover any personal belongings under the supervision of law enforcement.
Your Honor, if you'll just repeat that, Mr. Irizarry was speaking with me, I apologize.
All of it or just the most recent?
The most recent.
Okay. You will be permitted, sir, a one-time return to the residence to recover any personal belongings under the supervision of law enforcement. But you are to maintain separate residence from the victim.
Thank you, Your Honor.
Thank you. You may leave, sir. Thank you.
Thank you.
Okay, Chelsea Dawn Loki.
Yes, sir.
Good afternoon. I am appointing the public defender to represent you, the lawyer standing next to you. You're here on a charge of battery on a person 65 years of age or older. I've reviewed the charging affidavit and find that there is probable cause for the charge. The court will set bond at $500. Do they live together?
She was a
No, Your Honor, they do not reside together.
Okay, you're not to have any contact with the alleged victim as a condition of your release. That means no email, no text messages, no phone calls, no contact whatsoever, including in-person contact. Do you understand that?
Yes, sir.
Okay, anything further on this from the state?
No, Your Honor.
Defense?
Nothing from the defense, Your Honor.
Thank you, ma'am. Got a bunch of cases for this one. Deshaun Jordan Love. Good afternoon, sir. I am appointing the public defender to represent you. The lawyer standing next to you. We have 4 cases with you this afternoon. The first case, you are charged with failure to appear. Bond was set at, there was no bond set on this one, correct? Yeah, and no bond on this one, on the failure to appear.
Your Honor, on that failure to appear, Mr. Love tells me that it was a miscommunication between him and the bondsman and that he didn't have actual notice of the court date, that there was a misunderstanding, and he would ask that you set bond and allow him to clear this up and appear at all further court dates.
I understand that. The court is not going to set a bond now, but you have the right to seek a bond with the division judge, and if that's something you want to do, you should do that expeditiously, okay?
Thank you, Your Honor.
On the second case, you've been charged with possession of hydrocodone. I've reviewed the charging affidavit, the arrest affidavit, and conclude that there is probable cause for the charge. I will set bond at $1,000, and as a condition of release, you're not to have any drugs or non-prescription medications. On the next case, you've been charged with resisting officer without violence. I reviewed the arrest affidavit and find probable cause for the arrest. Court will set bond at $500. And on your last case, sir, you've been charged with battery, domestic in nature. The court has reviewed the arrest affidavit and finds that there is probable cause. The court will set the bond at $2,500.
Your Honor, defense would ask for a reduced bond of either 500 or 1,000. It is a misdemeanor domestic violence charge.
State, any position on?
State wouldn't object to a reduced bond.
Would?
Would not object.
Okay. Court will set bond at $500 as a condition of release. The defendant's not to have any contact with the alleged victim. Is the victim present?
We're not sure. There's two people out there. The lady in the yellow dress and the lady with the red hair.
She should be here. Her name is Alaric Gibson. You guys can call her from me.
Sir, again, I'm going to order no contact, but if there's something that you wish to have altered or amended with respect to the conditions of your release, you can file a motion with the division judge.
We can take care of that later, okay?
Okay?
How long will it take me to see my original judge?
You can speak with your lawyer in that regard.
Thank you, Your Honor.
Thank you. Okay. Ryder Pierre.
Yes, sir.
Good afternoon, sir.
Good.
I am appointing the public defender to represent you in this case. You are here on arrest for 4 charges. Count 1, aggravated battery on a pregnant person. Count 2, escape. Count 3, battery, domestic in nature. Count 4, resisting an officer without violence. I've reviewed the charging affidavit. I find probable cause on counts 1, 3, and 4. I need a little help on count 2. State.
Your Honor, if we could have 24 hours to just contact the officer for more information.
And here's why I asked, because when I look at the statute for escape, it kind of, it reads like they gotta get out of prison, not so much that they're running from an officer. Defense, any objection to a 24-hour on the?
I would object, Your Honor. I think that we need to go in the 4 corners of the charging affidavit, and I believe that there's no probable cause for escape if he wasn't actually under the custody of law enforcement or within the confines of a correctional facility.
Let me pull up the statute real quick. Oh, we do, okay. Just a moment. So state the escape statute says any prisoner confined in or released or on furlough from any prison, jail, private correctional facility, road camp, or other penal institution, whether operated by the state, county, or municipality, et cetera, who escapes or attempts to escape such confinement. Not so much that the officer arrives and they get out of their grasp, they got to actually be incarcerated somewhere. Am I missing something in that?
There's a different charge for that.
It would be a fleeing or eluding, I believe.
Correct.
Yeah,
Escape is not the
it
appropriate.
just seems like the wrong charge. So I'm not going to find. I'm going to find no probable cause on count 2 for escape.
Would you grant the state an opportunity to contact the officer to correct the charge?
That'll be done at a later time, Your Honor.
I believe you can just file that directly, correct?
Correct.
So I'm not going to reset IA, but if there's another charge that the state wishes to bring, that's their prerogative. RR on count 2, correct? Okay, so we have. I think we'd prefer not to have the child present during this proceeding. I don't.
Does she
I
have
don't know if there's-
care alternate?
I don't know if there's a way that we could,
Oh.
I don't want the child in here during this. I don't think that's appropriate. Correct, yeah, they can hang out there, but, yeah, I don't want, yeah, okay, good afternoon, ma'am. Could you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. If the defendant is released, do you wish to have any contact with him?
Yes.
Okay, do you have any fear for your safety if Mr. Pierre is released?
No.
Okay. Would you hesitate to contact law enforcement if another or any incident occurred between the two of you that caused you concern?
No.
Okay. The court will set bond on count 1 at $2,500.
Judge, he does qualify for PTR.
He does qualify for PTR, okay. The court will order PTR with bond? Direct? Yeah, okay.
It's at your discretion. He just qualified for PTR, but it's at your discretion.
So, Your Honor, he has no prior history of any kind whatsoever. So the defense would ask for straight PTR with no bond amounts set in these cases, especially since the victim is here and he has no prior history.
State.
The state would request that a bond be set.
In that case, we would ask for it to be as minimal as possible, maybe $100 each on all 3 counts.
The court is going to set a bond, and in light of the fact that resisting is one of the charges that creates a concern about compliance with, so the court will set a bond on count 1. So PTR with bond, count 1, bond will be set at $500. Count 3, bond will be set at $100. And count 4, bond will be set at $100. The defendant is to have no hostile contact with the alleged victim. That means, sir, that you are not to as much as raise your voice at the victim. If you have any hostile contact whatsoever with the alleged victim, you may be in violation of the terms of your release, and that's not a place you want to be. So make sure you follow that scrupulously. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Okay, thank you, sir. Thank you, ma'am. Correct. Got that? Okay. Edward Rockensteyer. Okay, reset?
Yes, Your Honor.
Reset for 24 hours. Osmond Kaneen Wilson.
Yes, sir.
Good afternoon, sir.
Good afternoon.
I am appointing the public defender to represent you, the lawyer standing next to you. You are here, sir, on charges of battery, felony battery, and battery dating violence. I've reviewed the arrest affidavit and conclude that there is probable cause for the charges. Actually, you're here on a warrant, is that right?
Okay.
This is a warrant arrest, correct?
Yes.
Okay. The court will set bond on count 1 at $5,000. And
Say
count
5,000, Your Honor?
5. And count 2 at $500. As a condition of your release, sir, you are not to have any contact with the alleged victim. Do they reside together?
They do live together, Your Honor, but the house apartment is in Mr. Wilson's name.
I've ordered that they maintain separate residences.
Don't worry about that right now.
On the he's out on bond on case 21 CF. This one? 2021 MM 7358. Trespass.
It's an attempt.
He's got two. Oh yeah. Let's see. I'm not going to take any action on the trespass case.
Thank you, Your Honor.
Sir, you're also here on a charge of burglary of a structure and grand theft third degree. I've reviewed, actually, also arrest warrant, probable cause has been found. Bond was set at $3,000 on count 1 and $500 on count 2. The court sets it at those amounts.
3,000 and
3,000 and 500. Yes, I what? Yeah, with the same conditions that were included on the warrant: no contact with the victim, no return to the scene. Well, was the scene his house?
Your Honor, he doesn't have a copy of any of these warrants or affidavits, so we would request that a copy be given to him here at the jail.
I'm setting bond at 3,500. So with the condition of no contact and no return to the scene.
But if the scene is his residence that's in his name,
Well,
so what if we put a condition on, not that. He's allowed to return to his home.
was the scene of this particular of the grand theft
I am,
and the burglary? Because if
I don't have the warrant. I don't have either of the warrants. I have arrest affidavits that say per warrant. Pull it up on the clerks and see if it's available there. Okay.
Counsel, I have it if you want to see it. Just a second, let me. Is the respondent, is the defendant's address, what is the defendant's address?
318 Eaton Street, Eatonville, Florida, 32751.
Thank you. This was a burglary at 707 West Washington Street, so. No problem. Thank you. Okay, so that, on that case was $3,000 on count 1, $500 on count 2, no return to the scene, no contact with the alleged victim.
Yes, Your Honor.
State anything further on this?
No, Your Honor.
Defense?
No, Your Honor.
Thank you, sir. I'm sorry? On separate residence on the first case. Not, this was a different victim, I think. Okay, Michael Bulkman. Good afternoon, sir. I am appointing the public defender to represent you. You're here on a charge of battery, domestic in nature. I've reviewed the arrest affidavit and find that there is probable cause for the charge. Court will set bond at $2,500. Defendants have no contact with the alleged victim. Do they reside together?
They do reside together, and the residence is in his name.
Okay, the court will order no contact, separate residences.
Your Honor, defense would ask for reduced bond amount. This is misdemeanor domestic violence of $1,000.
Any position from the state?
State has no objection.
Okay, court will set it at 1,000. Same conditions, no contact, separate residences. Although that, I don't want to put the victim out, but it is what it is. State,
If we could just, his address is listed as transient, if we could just have him fill out a change of address form.
yes, sir, sir, we need an address for you.
So,
Not on the record.
Yep.
Your Honor, I have that now. Fill out a change of address form.
Thank you. And, sir, you're also here in case 2021 MM7448 on a violation of probation for failure to appear at pretrial release intake appointment scheduled for November 2nd, 2021. Bond was set by the division judge at $1,000. And the court will set it, will keep it at $1,000.
Thank you, Your Honor.
Anything further from the state?
Were there any conditions associated with the VOP? Since it was a VOP of a battery charge, that's why I asked.
No.
Okay, thank you.
Thank you, Your Honor.
Thank you, sir. Okay, Andre Waldy Ernest. Good afternoon, sir. I'm appointing the public defender to represent you, the lawyer standing next to you. I've reviewed, you're here on a domestic violence battery charge. I've reviewed the arrest affidavit and conclude that there is probable cause for the charge. We have a witness present. Ma'am, can you state your name?
Randy Moss. Randy Moss.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, if Mr. Ernest is released, do you wish to have any contact with him?
Absolutely.
Okay, do you have any fear for your safety if you were to interact with Mr. Ernest?
No, sir.
Would you hesitate at all to contact law enforcement if there was a altercation between the two of you?
No, sir.
Excuse me?
I said no, sir.
I can't hear you.
I said no, sir.
You can remove your mask while you're talking.
Okay.
Okay. Okay.
Your Honor, defense would ask for straight PTR with no bond amount. He has no prior history. He qualifies for PTR. He's got a low risk assessment.
Any objection from the state?
No objection from the state.
And he does qualify for PTR?
Yes, sir.
Okay, the court will grant PTR with condition of no hostile contact with the alleged victim. No hostile contact, sir, means that you're not to as much as raise your voice against the alleged victim. Otherwise, you risk running afoul of your conditions of release. So you can have contact with her, but you can't have hostile contact. You understand that?
I understand.
Okay. Anything further from the state?
No, Your Honor.
Vince?
The question?
You can ask me first.
Oh, we're good.
Okay.
That's it, Your Honor. Thank you.
Thank you, sir.
So what do I do moving forward?
I'm sorry?
What do I do moving forward? As far as his release, do I just wait or?
You can contact with the lawyer and interact with him, with the public defender, but
No, what I'm asking is his release.
So the judge has ordered pretrial release with no bond amount, which means he doesn't have to pay to get out of jail. He just has to follow the conditions with pretrial release supervision, and they will release him, I'm guessing it'll take a few hours.
Okay, that's what I'm trying to figure
Yep.
out, if he's gonna be released today.
Correct.
I said no.
Yes.
And no hostile. You said no.
And no hostile.
And no
contact.
hostile, got it.
Right. That means that you guys can have contact, but there's no like yelling, screaming, hitting, none of that.
Okay,
raising of the
because
voices.
we live together, we have children together.
Uh-huh.
Can he come back home? I would like him
I'm not ordering no
home.
contact.
Yes.
I'm ordering no hostile contact.
So just no arguing, no fighting.
Yes.
And he's good to come home.
Yes.
Thank you, guys. Happy New Year.
Happy New Year.
Tiffany Ann Harnish. Good afternoon, ma'am. I'm appointing the public defender to represent you. You are here on a charge of battery, dating violence.
Yes, sir.
I've reviewed the arrest affidavit and have determined that there is probable cause for the charge. The court will set bond at $500.
Sir.
As a condition of your bond, you are not to have any contact with the alleged victim. Do they reside together?
Yes, yes, sir. We do. We're living out of a motel. We're basically homeless. I'm homeless, and we've been living out of the motel that they picked me up at.
Separate residences will be fine, Your Honor.
The court is going to order no contact with the alleged victim, maintenance of separate residences.
One-time return with law enforcement so she can get her belongings.
And you may have a one-time return under the supervision of law enforcement to recover any personal belongings. Anything from the state?
Yes, Your Honor, the state would ask for a higher bond. This defendant has a high risk assessment result. She has 2 prior failure to his peers from November.
Your Honor, the defense wouldn't have an issue with a $1,000 bond instead of $500, but that's about as high as defense is comfortable with on a misdemeanor domestic violence.
What did you say the failures to appear, when were they?
They are listed. Are you asking for the exact charges?
No, when were they?
November of 2021.
Was that, which case was that? 21?
I'm not sure. I can try to look that up.
Okay. Court will set it at 1,000. Ma'am, do you understand that you need to show up for your appearances? Do you understand that if you fail to appear again, that it's very unlikely that you're going to get a bond?
I didn't realize, I'm not making an excuse. I understand it now. But the pretrial release thing, I didn't understand that. And I'd missed a phone call. But no worries. I'm not gonna.
The other concern, ma'am, is you have another open case that you're out on bond on. I'm not taking any action on that case today, but I can guarantee you that that probably won't be the case if you fail to appear again.
Yes, sir. No.
You understand that? Okay,
Thank you, Judge.
Thank you.
thank you. All right, Michael Rana. Good afternoon, sir. I am appointing the public defender to represent you. You are here on a charge of battery, domestic violence. I've reviewed the arrest affidavit and conclude that there is probable cause for the charge. Good afternoon, sir. Can you state your name, please?
Sohail Rana.
I'm sorry, can you say that again?
Sohail Rana.
Okay, are you the alleged victim in this case?
Yes,
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. If Mr. Rana is released, do you wish to have any contact with him?
Yes,
Okay, do you have any fear for your safety if Mr. Rana is permitted to have contact with you?
I'm concerned about his safety as well as others because of his state of mind.
Okay, but, so are you saying that you have some concerns for your own safety if Mr. Rana is able to have contact with you?
Yes,
Okay, so do you wish to have contact with him? Do you want the court to say he's allowed to contact you or not?
he's allowed to contact me after he has undergone treatment.
Okay, so at this time, you're not comfortable having contact with him, is that fair?
Correct.
Your Honor, may I inquire of the witness?
You may.
Sir, what is the concern about his behavior?
He is diagnosed bipolar, and right now he's going through a severe manic episode.
Thank you for that information, sir. Are you comfortable with him when he is being treated?
He's not getting treatment because he's not taking his medication.
My question is when he is taking his medication, are you okay with being around him?
I'm not.
No? Not even on medication?
When he's on medication, I could be around him, yes.
Okay. Your Honor, defense would ask for him to be interviewed for mental health pretrial release.
State, do you have any questions for the witness before?
Your Honor, may I request that he be sent to a psychiatric facility?
We're not gonna be sending anyone to a psychiatric facility today. Today's the determination as to whether or not he's going to be released and under what terms he will be released. Does he qualify for PTR? What about mental health PTR? He may sit in here for a while before they can even interview him for mental health.
How long is a while?
At least 5 days, I'm being told.
Right. Then, Your Honor, my alternate proposal would be to do pretrial release with a condition of mental health counseling and treatment.
Hey, do you have any position on this issue?
The state would ask how that would be enforced.
So.
That is a struggle.
It is, we're struggling here to come up with something. And I feel like the resolution of this, the issue here sounds like it is 100% a mental health issue. So.
Where does he reside? Live?
With me.
Live together.
Is there any alternate, if the court were, I'm not saying I'm doing it, but if the court were to say that that the defendant cannot have any contact with the victim, where would, do we know where he would go?
The alternative housing option would be a hotel. So that is obviously a limited amount of time that he would be able to do that. But there is that option, and he can work with social services at my office to come up with other housing alternatives.
If I may, sir.
Yes, sir.
I'm fearful of him harming himself as well.
That's a different issue.
It is. I want to understand from your perspective, sir, whether or not you want him in your home. Do you want to have contact with him or not? Because that's what the court has to determine today, is whether or not he's going to permit contact, and then under what terms that would be.
At what time would that be?
Well, let me ask you this. Are you taking him back into your house? I mean, it's your home.
I am not ready to take him back at the house right now because of the state of his mind. And I'm afraid for him to be at large as well.
Your Honor, it looks like that he has no prior convictions whatsoever, so I'm not concerned for the danger to the community or flight risk. It appears that at this juncture, no contact with PTR is, and maintain separate residences, and then they can modify that later once they've gone down that road.
The court will set a bond of $1,000. The defendant is to have no contact with the alleged victim and to maintain separate residences. As a condition of, with PTR, correct? He's eligible? PTR, yeah. As a condition of release, he is to take all prescribed medications, mental health medications or otherwise.
If I may, Your Honor, how is that going to be enforced?
It's enforced through the same mechanism as any other. At the end of the day, it's a piece of paper, but it's a piece of paper that can be enforced through means that law enforcement enforce orders all the time.
He has been prescribed those medications already by his doctor, and he's not taking them.
I understand that. As a condition of his release, he will be required to take them. If he does not take them, his release, his bond will be revoked and he can be detained.
Your Honor, I again request that he be sent to a psych facility. Until then, he should remain in custody.
I'm ordering no contact with you, so he's not to have any contact. There's a bond of $1,000, so he's going to be in custody unless he posts a bond. So that's the state. If you have questions about that, you can talk with the state or victim advocates or with the public defender, okay?
How long will he be detained here until evaluation?
He's detained until he posts a bond.
How, and that could be 5 days, 10 days?
It could be forever if he never posts, not forever, but at least until trial, until he posts a bond.
Okay. And will he be evaluated during that time?
The jail provides health care, including mental health care. I don't know the extent of it, but again, if you have particular questions dealing with the specifics, you can contact, I think, victim advocates with the state who can help you out, okay? Thank you, sir.
Thank you.
Thank you, Your Honor.
Okay. Benjamin Bell. Good afternoon. I am appointing the public defender to represent you. You're here on a warrant arrest for aggravated stalking with a credible threat, written threats to kill or do bodily harm, and criminal mischief. The court has reviewed probable causes previously found in the warrant. The court is going to set bond on count 1 with bond, or he qualifies for PTR. Okay. Court order PTR with bond. I'll set bond on the first count, aggravated stalking with a credible threat, at $2,500 with no contact with the victim, no weapons or firearms, and no return to the scene. Count 2, bond will be set at $1,000. Same conditions. Correct, PTR on all. And count 3, bond will be set at $250. 2,500. Okay. Anything further from the state?
No, Your Honor.
1,000. Yes. 500.
You said 250.
Yeah, you did say 2.
I'm sorry, 250. It's well past the lunch hour.
Sorry, Your Honor.
Anything further?
Nothing further from the defense.
Thank you. Amade Jameen Connor, good afternoon, sir. I am appointing the public defender to represent you. You're here on a warrant arrest, count 1, aggravated battery, and count 2, criminal mischief. Probable cause has previously been found in the arrest warrant. The court also finds probable cause. Bond on count 1 is set at $2,500. Bond on count 2 is set at $150. And as a condition, you're not to have any contact with the alleged victim, and you're not to have any weapons or firearms. Okay?
Your Honor, defense would ask if you would be inclined to set bond in each case at $1,000 apiece. Mr. Connor is of limited financial means and would not be able to bond out at all. It would be the equivalent of no bond at the amounts that they're currently set.
It's only going to go down to like $600 total.
He only has about 250 total.
Okay. Okay. State.
State would request that bond remain where the judge has set it, given history. And that he's a high-risk assessment.
Yeah, the court's going to keep the bond as set in the warrant. 2,500 count 1, 150 count 2. No contact, no weapons or firearms. Thank you, sir.
Thank you, Your Honor.
Quavari Cummings. Good afternoon, sir. Okay. I am appointing the public defender to represent you this morning. Afternoon, I should say. We're here, you're here on 3 counts. Count 1, robbery, sudden snatching. Count 2, battery. And count 3, grand theft in the 3rd degree. The court has reviewed the arrest affidavit and concluded that there is probable cause for the charges. The court will set bond on count 1 at $1,000. Count 2 $500. Count 3 $500. Anything further from the state?
The state would request, since he's out on bond from a felony.
That's right, we got other 2 cases.
To revoke.
The court is inclined to revoke the bond in case number 2021 CF 12843 and 2021 CF 8336. Defense, do you have anything to add before I do that? Correct.
Nothing further from defense?
Okay, so did you catch the last part? The bond's going to be revoked in the 2 cases?
I did.
Okay, and bond will be set at 0 on those.
Yes, Your Honor.
Okay, thank you, sir. Elijah De Leon. Corey Flowers.
Yes,
Good
Your Honor.
afternoon, sir.
Good afternoon.
I'm appointing the public defender to represent you. you are here on a charge of aggravated battery with a deadly weapon and a second count for battery. The court has reviewed the arrest affidavit. Actually, you're here on a warrant. But I've reviewed the warrant and probable cause was found. I conclude that there is probable cause. I'm going to set. Okay. I will order PTR. I'm going to set a bond on count 1 at $5,000 and count 2 $500.
Your Honor, defense would ask for a reduced bond on count 1, closer to 1,000 or 2,500.
Any position from the state on bond amount?
The state would request that the bond remain at 5,000.
Yeah, the court will keep bond at 5,000. Count 2 at 500. The defendants to have no contact with the alleged victim.
Thank you, Your Honor.
Thank you, sir. Rickle Lewis. Is it Raquel? Ricky. I'm sorry, I saw your middle initial.
Sorry, Your Honor.
No worries. Ms. Lewis, I'm appointing the public defender to represent you. You're here on 2 counts. Count 1, possession of methamphetamine, and count 2, possession of drug paraphernalia. I've reviewed the arrest affidavit, determined that there is probable cause for the charges. The court will set, does she qualify for PTR? Okay. Court will set bond on count 1 at $500, count 2 at $500, with the condition of no drugs or non-prescription medications. Anything from the state?
No, Your Honor.
Defense?
Nothing from defense.
Thank you, ma'am.
Your Honor, may state and I approach on this next one?
You may. We have the on the hold on, let's wait for. Yeah, no, we're on. Do you want to be on? Okay, you want to go off? They want to be off. Okay, ma'am. You are here on 2 counts. 1 count possession of alprazolam and another count of possession of controlled substance. I've reviewed the arrest affidavit and conclude that there is probable cause for the arrest. The court is going to set bond on count 1 at $1,000, count 2, $1,000, with the condition of no drugs or non-prescription medications. As to your 2 open cases, case number 2019 MM 8916, the court is revoking the ROR, setting bond at 0. And in case number 2021 CF 13894, the court is revoking the bond and setting it 0. Anything from the state?
No, Your Honor.
Defense?
Your Honor, the only thing that defense would ask is that if she is released, that a condition of her bond on this current case be to comply with all mental health medications or treatment.
The court will require on the new case, as a condition of her bond, that she comply with all mental health treatment, including medications.
Thank you, Your Honor.
Thank you, ma'am. Best of luck to you. No drugs. Yep. And medication. Anthony Williams.
Mental health, Your Honor.
Okay. We reset 24 hours.
24-hour reset, Your Honor.
Yeah. Yeah.
That's the next day, right?
Yeah.
Oh, so you want, you said it was. So.
Tomorrow.
Yeah, tomorrow. Yeah. It doesn't have to be at 1:52 p.m. tomorrow.
Somebody feed the clerk.
Just, they're with it. Whew.
Okay. Jose Cardona.
Yes, Your Honor.
Okay, sir, you are here. I appoint the public defender to represent you. You're here on a charge of DUI. I've reviewed the arrest affidavit and conclude that there is probable cause for the charge. Court will set bond at $500. Okay, direct PTR. Okay. All or PTR, no bond. State, you want any conditions on this?
No alcohol.
No alcohol.
Thank you, Your Honor.
Thank you. Okay, Christy Fabo. Good afternoon, ma'am. I am appointing the public defender to represent you, the lawyer standing next to you. You're here on a warrant arrest for failure to appear for arraignment.
Yes.
Bail was set at $2,000. The court will keep it at $2,000. Anything from the state?
No, Your Honor.
Defense?
No, Your Honor.
Thank you. Keeson Pender. Keeson, good afternoon, sir.
Good day, sir. Happy New Year's, everyone.
Thank you. All right, sir, I am appointing the public defender to represent you. You're here for a failure to appear for arraignment. Bond was set at $2,000, where it will remain. Okay?
Thank you so much. I appreciate that.
Yes. Okay, Kamoy Akim Fields. Good afternoon, sir.
Good afternoon. Good afternoon.
I am appointing the public defender to represent you, sir. You are here on an arrest for two charges, one count for battery, one count for petty theft.
Yeah.
I've reviewed the arrest affidavit and determined that there is probable cause for the arrest.
Yes, sir.
I will set bond on count 1, $500.
Yes, sir.
Count 2, $250. On the condition that you are to have no contact with the alleged victim of the battery, and also no return to the scene of the theft. Do you understand that? Does the state have a position on the open case 2021 CF 3148?
The state would request that bond be revoked in that case.
Defense have anything to say about that?
Your Honor, defense would ask the bond not be revoked, but instead maybe set a new bond.
The court's going to revoke if on the bond and set it 0 on case 2021 CF 3148. If you think you'd like to have that changed, you can file it with the division judge.
Yes, Your Honor.
Thank you. Thank you, sir.
Appreciate it.
Okay, John Doe, although I'm not sure that this is John Doe. Do we have a name for this?
There is.
Okay. I'm sorry, my cover sheet says John Doe.
Is it Stephen Richardson?
I don't, this is Mr. Sanchez, so.
Okay.
Stephen Richardson? Okay. You want to reset, or do you want to waive?
We can reset in 24 hours, Your Honor.
Okay, we'll reset Mr. Richardson for tomorrow. Eddie Sanchez. Good afternoon, sir. I'm appointing the public defender to represent you for this proceeding. You're here on a charge of trespass on property after warning. The court has reviewed the arrest affidavit and determines that there is probable cause. Court will set a bond, $250. Court will set a bond at $250 with no return to the scene.
Your Honor, defense would ask that he be able to leave the state of Florida as his current residence is in New York, and he promises to return for all future court dates.
Any position from the state on leaving Florida?
The state has no position, but could we get an address in New York for him since he's listed as transient?
I believe it's in, well, no, you're right, we don't have it, we have transient. If we could get an address, that would be helpful. The court, he will be permitted to return to New York. Bond will be set at $250. No, no rush. I think, do you need to change address form?
I'll get it
Okay.
afterwards.
Because I be ready to go. You gonna let me.
Economy here.
I set a goal for 2 p.m., we're getting there.
Yeah.
Judge, you got 2 minutes.
As long as we don't need Bengalese, I think we're gonna be good. Shitel Thompson.
Yes, sir.
Good afternoon.
Afternoon.
Ma'am, I'm appointing the public defender to represent you.
Yes.
You're here on a charge of trespass to property other than a structure or conveyance. I've reviewed the arrest affidavit and determined that there is probable cause for the charge. Court will set bond at $250.
Your Honor, defense would ask for a reduction to $100. Looking at the prior history, it appears that she may be alternatively housed and therefore of limited financial means.
Any position from the state on 100 versus 250?
Your Honor, I was going to ask for a raise. She has 3 failure to appears from October of 2021.
Yeah, the court's not going to decrease it. I'll keep it at 250 for now. No return to the scene.
So what's going to happen today? Am I going to get released? Am I, what's going to happen? I'm not going to bond out, so I'm going to be here.
Then your attorney,
Jessica Yun,
Behavior, Your Honor.
okay, reset for tomorrow.
Yes, Your Honor.
Nicole Ann Chartier. Ma'am, you're here on an out-of-county warrant, I believe, from Lee County. You'll be transferred to Lee County. Bond is still at 0, right? Until you can be dealt with in Lee County, okay? Thank you, ma'am. Chester Dyson,
Refuse, Your Honor.
okay? Reset? Or would you like to,
Your Honor, do you know how many times this has been reset?
I don't know.
And defense would waive Mr. Dyson's appearance and ask that the court set bond in this case.
Okay, the court appoints the public defender to represent Mr. Dyson. Mr. Dyson has waived appearance through counsel at the initial appearance. He has four counts. Count 1, throwing a deadly missile into an occupied vehicle. Count 2, aggravated assault with a battery. Count 3, criminal mischief. Count 4, battery. Court has reviewed the arrest affidavit, finds that there is probable cause for those charges. Court will set bond on count 1 at $5,000, count 2 $2,500, count 3 $500, count 4 $500 on the conditions of no contact with the victim and surrender any weapons and firearms. Anything further?
I have more cases on mine.
Oh, do you?
I do as well. And actually, the state didn't receive a charging affidavit.
It's a warrant.
There's just a warrant. Can we get a copy of the?
Sure.
That?
Not to have any weapons or firearms, surrender weapons and firearms within 24 hours
Of release.
of release, correct.
Thank you.
Yes, did you want to see the arrest warrant?
Could I have a copy of it just for our paperwork?
We can't make, I don't think we can make them. Can we make them? It's in the clerk's website.
Okay, would you just mind repeating the bond amounts then? I apologize.
I'm sorry, yes. $5,000 for count 1, $2,500 for count 2, $500 for count 3, and $500 for count 4.
Thank you.
This was not a this was
2021 CF 1340.
Yep. 13400. Okay, so on the next case for Mr. Dyson, case number 2021 CF 1222, he's been charged with count 1, grand theft, 3rd degree, count 2, criminal mischief with damage of $1,000 or more.
Your Honor, I show this as failure to appear.
Oh, this is a failure to appear, correct. Bond was revoked and not to be modified at initial appearance. So bond is at 0 on both those counts. Okay. His next case is 2021 CF 15547. Count 1, dealing in stolen property. Count 2, receiving money from pawnbroker, false verification. This was also on an arrest warrant. Probable cause was previously determined. Bond was set. Bond is set on count 1 at $1,000 and count 2, $150.
Thank you, Judge.
And last case for Mr. Dyson is 2021 MM 9313. Charged with resisting an officer without violence. I've reviewed the arrest affidavit and have determined that there is probable cause for the charge. Bond will be set at $500.
Thank you, Your Honor.
Thank you. Need me to slow down at all over there? You good?
I think so.
You get all that? Say. Okay. Ada Figueroa.
Behavior.
This is, you want to reset or
Do
would
one
you like to?
additional reset, Your Honor.
Okay. We'll reset for tomorrow. Elijah Reed.
Medical.
Medical, okay. Reset for tomorrow. Behavior. What about Mr. Reed?
One additional reset, Your Honor.
Okay, we'll reset for tomorrow with Mr. Reed. Tyrone Thompson.
Mental health.
Reed was medical, yeah.
Your Honor, could we waive his appearance and go ahead and set bond in this case? It's a trespass misdemeanor.
Sure. Okay, so the court will appoint the public defender to represent Mr. Thompson. Appearance of Mr. Thompson's been waived. The court, he's been charged with trespass on property after warning. Court's reviewed the arrest affidavit, finds that there is probable cause for the arrest. Bond will be set at $100.
Thank you, Your Honor.
No return to the scene. Okay, Luis Almonte. Good afternoon, sir.
Hi.
I am appointing the public defender, the lawyer next to you, to represent you this afternoon. You're here, sir, on a charge of disorderly conduct. I've reviewed the arrest affidavit and determine that there is probable cause for the charge. Court will set a bond at $250. Anything further from the state?
No, Your Honor.
Defense?
No, Your Honor.
Thank you, sir. I skipped one? Yeah. Yeah. I think we skipped one earlier. Vincent Lamar Williams.
Yes, Your Honor.
Is that you, Mr. Williams? No. Okay, do you wish to waive?
Your Honor, I will do one more reset, but if he is still not available tomorrow, then I would ask that we waive.
We'll reset for tomorrow. State, any position?
Huh?
Any position or concern about that?
No.
I saw a brow furl a little bit, so I wanted to make
the
sure.
state just, things were a little out of order.
Yeah, I apologize. I took that one out of order.
It's all right.
Mark Kane. Good afternoon, sir. Sir, I'm appointing the public defender to represent you. You've been charged with disorderly conduct. I've reviewed the arrest affidavit, determined that there is probable cause for the arrest. Set bond at $100. Anything from the state?
No, Your Honor.
Vince?
No, Your Honor.
Thank you. Denver Freeman?
How you doing? I got verified.
We can do, okay?
Good afternoon, sir. We're here, I'm appointing the public defender to represent you this afternoon, sorry. You're here on a charge of disorderly conduct. I've reviewed the arrest affidavit, find that there is probable cause for the arrest. State, do you have a position on bond for this?
No, Your Honor.
Vince?
Your Honor, Mr. Freeman would ask for ROR. He has already spoken with pretrial services, he says, and he's got a bed waiting for him at a halfway house, and he would like to be able to be released to go to that, to get the services that he needs.
PTR, do you have any information for me on that?
Sir, I've been speaking with a halfway house called Solutions by the Sea in Daytona Beach. Yesterday, while I was with pretrial services, we called their intake coordinator. His name is David Jackson, and he told me, he said, if I can get out, that they will come and pick me up from here, and that, you know, they would be responsible to make sure that I got back and forth for court and all that.
We did notify someone at PTR that he was going to a treatment center in Daytona, Solution by the Sea, once released.
Yes, sir. It's a halfway house. It's a halfway house. It's like they make you go to AA meetings every day.
I understand, and you're starting in that program as soon as you get out of here? Is that what you're telling the court?
Yes, sir. Yes, sir.
He
They've been.
says they're gonna come pick them up.
Okay.
Pick them up.
Yeah, they've been holding the bed for me.
The court will ROR him.
Okay. Your Honor, I did see a note that he wanted to make a plea offer. The state would have no problem with him pleading out if he wants to do that.
Okay.
You want to do that now, or?
Defense doesn't make plea offers, so does the state have an offer?
Adjudication of guilt and court costs and credit time served.
Yep.
Yeah, that's fine.
Your Honor, if you'll give us a moment, we'll.
Sure.
Thank you, sir. I'm trying to get my life together. I don't want to keep having.
I understand. Thank you.
Your Honor, may I approach with the plea form?
You may. Okay, sir, you wish to enter into a plea to guilty of this charge today?
No contest.
Okay, it's a no contest plea.
Yes, Your Honor.
Sorry, I'm jumping the gun.
That's okay. Do you want me to present?
You may.
Okay. Your Honor, Mr. Freeman would like to withdraw his plea of not guilty and enter a plea of no contest. The agreed upon disposition with the state is an adjudication of guilt, credit for time served, and court costs.
Okay, sir, do you understand that, is this a knowing and voluntary plea?
Yes, sir, it is.
You understand that you're going to be adjudicated guilty?
Yes, sir.
Okay. Okay, the court will adjudicate the defendant guilty, accept the plea, and court costs and time served. Is that what the basis?
Yes, Your Honor.
Okay. Court costs and time served. 1 year? Yeah. 1 year to pay the court costs.
Thank you, Your Honor.
It's 200 and, how much did you say? $223.
Is it 1 day credit time, sir?
How long has he been in? How long have you been in, sir?
I got arrested yesterday at 8 o'clock.
2 days.
2 days. Thank you, sir. Best of luck to you.
Thank you.
All right. Stephen McCarter.
You, Ms. Carter? Okay.
Good afternoon, sir. I'm appointing the public defender to represent you. You're here on a charge of disorderly conduct. I've reviewed the arrest affidavit, determined that there is probable cause for the arrest. Any position from the state on this?
No, Your Honor.
Okay. Defense?
Your Honor, defense would ask for either ROR, PTR, or in the alternative, a very low bond of like $100. By looking at Mr. McCarter's prior history, it appears that he may be alternatively housed and of limited financial means.
Court will set bond at $100.
Thank you, Your Honor.
Thanks. And our last defendant, Cecil Simmons. Good afternoon, sir.
Good afternoon.
Sir, I'm appointing the public defender to represent you this afternoon. You're here on a charge of disorderly conduct. I've reviewed the arrest affidavit and have determined that there is probable cause for the charge. Bond will be set at $200. Anything further from the state?
No, Your Honor.
Defense?
Your Honor, the defense would ask for a reduced bond amount in the amount of $100 or ROR. And also, Mr. Simmons is inquiring in regards to this detainer about a local warrant. He was told that he has a warrant, but he has not been served that warrant at this time.
Once he's served, we can't do it till he's served.
Yeah, there's nothing I can do on that charge. As to the bond,
Do we know when he's going to be served? Reach out? No.
as to the bond amount, court's gonna keep it at 200. Thank you, sir. Best of luck to you. Anything further from the state today before we go off the record?
I had some cases.
Oh, I'm sorry, hold on. Miss Greer stepped out.
The ones that just like don't get addressed, is that they just bond out or?
The ones that we reset?
No, not reset. I had some.
You have some that weren't called?
Yeah. I don't know.
They bonded according to,
All of them.
how many do you have?
Have four?
Not you, I'm asking her so we can see if they match up.
I have 5.
I have, Eric McDaniel, bonded.
He bonded.
John Martin, bonded. Dave Killinger,